How does a civil lawsuit compare to a criminal lawsuit? A civil lawsuit typically starts with a complaint or a petition, which sets out the allegations as to why relief is needed, what relief is sought, and provides a general legal theory under what relief can be granted. At this stage, allegations have not been proved and are usually a one-sided rendition. The person or organization who files a complaint or a petition becomes known as the plaintiff or petitioner. A criminal case typically begins with either an arrest or a citation. Arrests start with a warrant request, where the prosecuting attorney determines whether a person should be charged with the crime, and if so, what exactly that crime should be. The prosecutor reviews all reports and records concerning the case, including witness statements. Once the prosecutor is convinced there's enough information to believe that a suspect actually committed a crime, a warrant for arrest is issued and the suspect is brought into custody. The suspect is typically held in custody for about 36 hours while the criminal complaint is prepared. In cases where an individual is not arrested, usually misdemeanors or petty misdemeanors, then suspects are charged with the complaint, warrant, and actually mailed the citation. The next step of a civil case is called early motions. If immediate relief is necessary, usually due to time constraints, then the complaint will come with a motion requesting a temporary restraining order. This allows the status quo to remain until a hearing can occur. Such motions are referred to as extraordinary, but are often granted, typically for about 10 days without a hearing, so the court and parties can determine if the matter before the court should be expedited. The next step in a civil case is the answer or the pleading. The defendant or respondent, that is the person or entity being sued, usually has a limited amount of time to file a response or seek an extension. Responses can be either an answer in which the allegations are admitted or denied, or a responsive motion or pleading that outlines defenses or makes cross-claims and counterclaims. The next step in a criminal case is the initial appearance or preliminary hearing. The initial appearance usually occurs about 24 to 36 hours after an arrest. This, of course, works differently if you're only facing misdemeanor charges, and the timing varies based on the jurisdiction. During this appearance, the judge advises about potential charges. The arrested individual must enter a plea of guilty or not guilty. Bail bond conditions and amount are usually determined by the judge. After initial appearance comes the indictment. In most jurisdictions, formal charges must be filed within a certain number of days from the arrest. Either the court or a grand jury, in cases of serious felonies, will determine if there is sufficient evidence for the suspect to be convicted by a jury. Following the indictment comes the actual arraignment. During the arraignment, the defendant is informed of what the formal charges are, those charges that are outlined in the indictment or the complaint, the maximum possible penalties if the defendant is convicted, and they are also advised of their constitutional rights. At this time, the arrested individual must also enter another plea of guilty or not guilty. The next step of the court process is actually two steps that occur in both civil cases and criminal cases. These steps don't necessarily occur in a particular order. In fact, they can both be ongoing at the exact same time. The first one of these is pretrial motions. Some motions can proceed without a formal hearing, and others the court actually schedules a time to hear. The cases usually proceed even if a motion is granted, except of course in a case of a motion to dismiss. Not all motions are used in both civil and criminal proceedings. When it comes to discovery, it's all about the parties attempting to identify and gather the information they need to prove or counter the allegations at trial. Much of the information is gathered through informal interviews, searches of documents, interrogatories, and depositions, which of course are recorded interviews of potential witnesses. In criminal cases, the state has the obligation to disclose any evidence it has against the defendant. After pretrial motions and discovery comes pretrial conference. Typically what happens is that at least once both sides get together, decide if a case will be resolved via plea agreement or settlement, or whether it should proceed to trial. Sometimes this will occur between the parties on their own initiative. Sometimes the court requires them to do so, and the judge even may participate in the conference. If the conference is unsuccessful, then sometimes the parties are required to complete a pretrial order, providing the court with details about their case, when they will disclose their witnesses, how long the trial will take, etc. When cases are not resolved at earlier stages, they proceed to trial. Trials can either be bench trials, in which the judge decides both fact and law, or jury trials. in which the judge presides and determines the law, but the jury makes most of the factual determinations. Certain aspects of the trial are similar whether a case is tried to a jury or tried to the bench. For example, in both, the attorneys have the right to present an opening statement, which provides a roadmap of what the party intends to prove. The party with the burden of proof, usually the plaintiff or the state, goes first, and such statements are generally short. Then evidence is presented, using live witnesses who are questioned by each side and through documents obtained during discovery. At the end of the trial, attorneys for each side make closing arguments, commenting on the exhibits and testimony, and a decision is made by either the judge or jury. In both types of proceedings, defendants can move at the end of the plaintiff's case for a ruling based on the theory that the plaintiff or the state failed to prove its case. Throughout the trial, lawyers may object to certain questions, answers, or exhibits based on the rules of evidence. The judge decides whether the objection shall be sustained, meaning evidence is excluded, or overruled, where evidence is admitted. After receiving a decision, either party can bring various motions attempting to have that decision or verdict set aside or modified. These motions are generally made within a month of the trial verdict. Common motions after a jury trial include asking the judge to override the jury, a motion for judgment notwithstanding the verdict, to grant a new trial, to acquit the defendant, pointing out deficiencies with jury instructions, or evidential rulings. Following the post-trial motions, there are several other steps involved in a criminal case. One of these is pre-sentencing investigation. The court's probation department prepares a report for the judge summarizing the crime and the defendant's personal and criminal backgrounds. Generally, the victim is contacted for a recommendation of sentence. The probation officer concludes the report with the recommended sentence. After the pre-sentence investigation comes the actual sentencing phase. Sentencing varies with the crime, but it is usually at the judge's discretion. The judge will consider the information in the pre-sentence report, additional evidence offered by the parties, comments offered by the victim, and other relevant information. With most felonies, a sentencing guideline is also consulted. Sentencing usually results in a fine, probation, community service, a sentence to jail or prison, or a combination of these factors. The judge can also order the defendant to make restitution to any victims who have suffered financial harm. Once all post-trial motions and the sentencing phase have been completed, then a party has the opportunity to appeal. A losing party may file an appeal, usually within 30 days of the entry of judgment or a final order, that challenges errors of the law or evidentiary rulings. Appellate courts do not hear or reweigh evidence, but make their decisions based on the trial record. The first step of the appeal, besides filing the actual notice, is usually when transcripts are requested and filed with the court. The district court will also forward the records at this point. Then, the appellant or the petitioner will file their brief. In response, the appellee or respondent will file their brief. And then after that, the appellant or the petitioner both have an opportunity to file a reply brief. After this, oral arguments are scheduled. The times vary depending on jurisdiction. Typically, the appellant or petitioner will get 15 minutes to present their argument. The appellee or the respondent has 15 minutes to respond, and then the appellant or petitioner will have another 5 minutes for rebuttal. Arguments are usually heard by panels of 3, 7, or 9 judges. After oral arguments are heard, the appellate court will issue their opinion. The panel that heard the oral argument will consider the briefs and conference on the case. The authoring judge writes an opinion that is circulated to the remaining judges on the court. After everyone has time to review and comment internally, the opinion is issued. Opinions can be published, unpublished, or issued as simple order opinions. The appellate court opinion is not always the last stop for the parties. Usually within 30 days of the appellate opinion, the losing party can file a petition for review or for petition for certiorari, asking the highest appellate court in the jurisdiction to review the case. The appeal is not based on what the intermediate appellate court did, but rather a second review of what the district court or trial court did. The court can then choose to certify and hear the case. Depending on the jurisdiction, it's usually 3 or 5 judges that need to agree to hear the case before it is accepted. Once certified, it follows the same basic structure as an intermediate appeal. Briefs are filed, oral arguments are heard, and the court issues an opinion. This opinion, generally, is the last word on the case. If the appeal is not certified, the case ends here. How does a federal case compare to a state case? Well, it depends largely on the jurisdiction. In the state of Minnesota, there are 10 judicial districts. These districts consist of 87 counties and are made up of 289 judges. The federal courts, on the other hand, consist of the entire 8th Circuit, which includes 7 states and 10 different district courts, but only has 42 judges. With those numbers, as you can imagine, the case volume is probably significantly different. In federal court, there are about 18,000 cases filed every year. Compare this to Minnesota State Court, which sees 2 million cases filed each year. One important thing to note is that 85% of cases that are filed actually never go to trial. Now, if one of the opinions from the 10 judicial districts within Minnesota State are appealed, they're appealed to the Minnesota Court of Appeals. Of course, there are 3 exceptions to this rule: murder cases, tax cases, and lawyer discipline cases. The Minnesota Court of Appeals handles about 2,400 cases each year. Of these appeals filed, the most common ones are criminal, followed closely by civil, family law, economic security, which is typically unemployment cases, juvenile cases, commitment cases, and implied. When cases are appealed from the 8th Circuit, they're appealed to the United States Court of Appeals for the 8th Circuit in St. Louis. The 8th Circuit Court of Appeals hears about 3,300 cases per year. These cases, the most common of course, are criminal, similar to state court. They also include prisoner appeals, other civil cases, administrative cases, and bank. As mentioned earlier, the Intermediate Appellate Court is not the last stop for some cases. When cases from the Minnesota Court of Appeals are appealed, they're appealed to the Minnesota Supreme Court. About 800 cases every year are petitioned to the Minnesota Supreme Court. The Supreme Court only grants about 80 of these cases. Plus, they also hear 120 direct appeals from the lawyer discipline, murder, and tax cases. When cases from the United States Court of Appeals for the 8th Circuit are appealed, those are petitioned to the Supreme Court of the United States. About 10,000 cases a year are petitioned for certiorari for the Supreme Court. The Supreme Court only hears about 75 of those cases. Now that you've been given an overview about civil cases versus criminal cases and state court versus federal court, there's one main key to appellate practice that you need to remember. Do you have jurisdiction to bring an appeal? Ask yourself, is there a final decision? Is the notice of appeal sufficient? Is the notice of appeal timely? That is, did you file it in time? Always check the rules of the jurisdiction you're in. And remember, federal and state are different.